Welcome to the Capitol Forum's interview series. My name is Jonathan Rubin, and we're pleased to have with us Michael P.A. Cohen, who is a partner at Hastings and chair of the Worldwide Antitrust and Competition Practice. Michael, welcome, and we'll jump right in.
Thank you. Nice to be here.
What is the Antitrust Division's litigation-ready policy?
Well, I don't purport to know that from the inside. From the outside, what we see is a posture at the agency to be in a trial preparation mode during its merger investigation, such that it is ready for trial to challenge a merger if and when that time arises at a particular point in the investigation. So to put it another way, it's trial preparation from the get-go.
Okay, is that really a policy?
I don't know so much that it's a policy, but it seems to be a change in the methodology. It's certainly a term that the staff and the decision makers at the agency use frequently. When I think of policies, Jonathan, I think of written things, and I don't know that that's into the written operations manual or anything to that effect, but it is certainly a living posture that the agencies have taken in connection with review of mergers that have any potential for competitive implications.
Is there some criticism that you have of it? Isn't it incumbent upon the agencies to prepare their cases as thoroughly as they can before the review process gets going, and that sort of also includes getting ready in the event litigation may be necessary?
There is an important role that the agencies play in being ready to challenge a merger that they may need to, and to the extent that that role requires the taking and gathering of evidence during the investigation in a way that would be usable at trial, it would be incumbent on the agency to do just that. There's also a danger, and the danger is in the normal advocacy role that comes out in the human dynamic anytime you flip the switch in your mind to prepare for trial. Once that occurs, there is a concern, a real and deliberate concern on anybody's part, that you've left the mode of investigator and are now in the mode of prosecutor. It's the same mode that a criminal prosecutor has to go in and out of probably 14 or 15 times a day as an assistant U.S. attorney. But it's not at all clear that the division in a merger investigation should be playing that type of role from the get-go. And so the danger is that it colors the independence of the merger investigation, the objectivity of the merger investigation in how the agency receives data. Is the agency now receiving and filtering data that is good for their case and putting it in one bucket, ignoring perhaps customer evidence that may be supportive of a merger as another bucket, as a bucket that they have to deal with, but not something they would consider in connection with the review, those types of things. I'm not sure that this agency has that kind of experience and that number of cases where they can flip that switch back and forth in a normal, routine manner. It postures, potentially, the defending parties into a pre-indictment mode rather than a merger investigation mode, if that makes some sense.
Well, yeah, how does that impact, for example, your practice in shepherding mergers through the review process?
Parties now look at everything they give the agency as evidence that will be used against them from the get-go, rather than evidence to convince the agency that there isn't a problem.
And you are you, or have you noticed that other parties, therefore, are sort of keeping their cards closer to the vest because of this fear that too much information might turn around and be used against them?
Absolutely. and the reason is this. Parties now, when the agency takes a litigation-ready posture, the parties are going to take a pre-indictment posture. And as a consequence, they're going to try to work with the agencies constructively and transparently, and at the same time, be prepared for a complaint. If the agency's posture is, well, if we have any probable cause or we have any notion of a case, we'll file a complaint and resolve it post-complaint through a Tunney Act process or a consent decree process, depending on the agency, then the parties are also going to reserve argument and evidence for that event. Previously, I think parties trusted the agency more than they do now. AT&T was significant in this regard, not so much because the agency sued, but when the agency sued. I don't think the parties were done presenting their evidence to the agency. They didn't feel as though the process were at a stage of indictment. They felt as though they were still in a dialogue of sharing. When you pull out a gun and indict somebody in the middle of an investigation, that's significant. It causes defense attorneys to potentially approach matters differently, particularly defense attorneys who have either been prosecutors at some point in their career or do a lot of pre-indictment work. The agency is now signaling that it is not a reviewing agency, but a prosecutorial agency. And, in fairness for the Antitrust Division in particular, it is. It's part of the Department of Justice. But it has a criminal division, or section, that is largely viewed as the prosecutorial arm. The other has largely been seen as a civil review arm. I think that's changed.
So if you were, we'll do a hypothetical, you're the head of the Antitrust Division now, and you're decide to write a policy for the division. How would your policy look to correct this? Would you have some sort of bright line between the investigative function and the litigation function? What would you tell your folks at the Antitrust Division?
I think if I were the head of the Antitrust Division, which is, I think that I would always instruct staff to collect evidence in a way that is usable for them in the event they need to enforce, which is going to court. But to be extraordinarily cautious in how they exercise their discretion during the merger review process, and do something to give parties assurances that there will be independent decision making, that there will be a normal process that is followed, that they're not going to be the subject of a complaint on 2 days' notice at an odd time during the investigation, but that indeed, here is the process. You're going to have access to the decision makers. You're going to have access to at least some timing consideration that gives everyone a fair shake, or at least creates the true objective period for arguments at the agency level. The agency can kind of take two postures on this. It can be an agency where it tries to make decisions, prosecutorial decisions, which, as I said, come with great discretion and responsibility, extra discretion and responsibility, because there's power in prosecuting cases. And then the other position is, well, the courts can sort it out. We're just looking for probable cause. The agency needs to decide which one. A criminal prosecutor looks for probable cause. That is a fairly low standard based on unilateral evidence collected at one point in time, without input from the parties. Make a decision and proceed to court. Those kinds of prosecutors exercise extra discretion over evidence because they are in court every day with that evidence and they view it that way as to what will be material in a court of law. An agency has advantages to not have to do things that way. An agency can, in essence, afford parties more latitude with evidence and make its own decisions about whether or not to proceed to enforcement by standards that could be more or less than probable cause, but they ought to be articulated to parties. There ought to be some definition as to what it is. And that's the danger, I think, Jonathan, in the litigation-ready posture. It sounds, and the agency talks about it in a way that sounds as if you need to be in a pre-indictment mode and guarded rather than a transparent, more constructive, sharing evidentiary mode. Not every case is going to be the same. You're going to have a feel for different cases, and all of those things are fair. But giving parties clarity as to what your policy is. When I find one bad document on a board deck, I'm going to court. If that's the policy, that's fine. Let's all know that up front. You're going to produce that document with your 4 Cs. If it relates to the merger and the transaction, fits the criteria, everybody knows the posture.
Mm-hmm.
But if there's a fair chance that you can talk about a bad document with the agency, if there's a fair chance that you can show the agency that this particular document doesn't matter in the context of the overall transaction, the parties ought to be afforded that chance. Right now, I think that if you had a bad document and a 4C and you produced it right away, you'd be advising clients differently and you'd be taking very different postures with the agency all the way through. Second request, etc.
Well, this is absolutely fascinating. We're almost out of time, so I'd ask you for a short answer on this. And the question is, now that you've made this observation or that this change has come about that you've observed, is there any way of getting the toothpaste back into the tube? In other words, will parties ever come to reach that ideal of being as fully open with the agencies as the agencies would like?
Sure. I think that, you can be, I think the agency can articulate what it means by litigation-ready policies. I think that there's a perception, and at least among many in the defense bar, that currently what that means is we are geared to file a complaint if we hear unilateral evidence that leads us anywhere close to that direction.
Shades of bizarre voice?
Shades of bizarre voice.
Where some hot documents might have been the motivation for the litigation, but may not have had the probative value or may have been given too much probative value in a sense.
Absolutely. Or maybe even in a transaction that, as a whole, wasn't quite that important, and may have been one that could have been viewed more holistically in a nascent technology industry with titans who could simply extend any one of their products into the market.
Right.
So whatever they might have thought may have been wrong, may have been right, but should have been probed perhaps differently.
Right. Michael, very interesting perspective, and we thank you so much for joining us and look forward to having you back again.
Thank you, Jonathan. It's nice to be here.
Thank you.